Staring at this backdated quitclaim deed triggers the brain's illusion of control, but cognitive tunneling physically blinds the prefrontal cortex to peripheral threats. That exact neurological blind spot cost one sibling a lucrative commercial estate. This is the story of a family estate, a fabricated timeline, and a dormant municipal liability that lay buried in city archives for 4 years. Names and specific municipal identifiers have been changed for privacy, but the legal mechanics and financial consequences remain entirely intact. My name is David. My older brother is Marcus. And our father, Arthur, was the sole proprietor of a mid-century commercial textile building in the downtown Arts District, alongside our family's suburban residential home in Oak Creek. For a decade, Marcus managed the commercial leases. He viewed the downtown property as his birthright. I, on the other hand, managed our father's medical care and the residential estate. When Arthur suffered a severe ischemic stroke on October 12, 2022, the family dynamic shifted from passive inheritance to active triage. By November, Arthur was nonverbal and residing in a long-term care facility. It was during this window of incapacity that Marcus began making quiet inquiries about bypassing the probate process. In estate law, a quitclaim deed is a mechanism that transfers whatever interest the grantor has in a property, without any warranties of title. It is a fast, quiet instrument. Crucially, it allows an asset to bypass probate, transferring directly to the grantee upon the grantor's death, or immediately, if executed while the grantor is alive. Marcus wanted the commercial building transferred to his LLC immediately, avoiding the 12 to 18-month probate freeze. But to do this legally, he needed Arthur's signature. And by November 2022, Arthur lacked the cognitive capacity to provide it. I will explain later how a single municipal ledger entry from 4 years prior dismantled his entire strategy. But first, we need to establish the timeline of the deception. Arthur passed away on January 18, 2023. The reading of the will and the initial probate filings occurred on February 2. I expected the estate to be divided cleanly, the commercial building to Marcus, the residential home to me, as Arthur had verbally indicated for years. But during the February 14 probate hearing, Marcus's attorney submitted a recorded quitclaim deed. The document transferred the downtown commercial property from Arthur to Marcus's LLC. The date of execution on the document was August 14, 2018. Marcus claimed our father had signed it over 4 years ago, during a routine estate planning session. If true, the commercial building was never part of the probate estate. It already belonged to Marcus. The judge noted the deed and temporarily sealed the commercial asset from the probate inventory, pending my right to contest. I didn't react emotionally. I reacted procedurally. On February 20, I retained a forensic document examiner and a title archivist. We weren't just looking for a forged signature, we were looking for chronological anomalies. The first piece of tangible evidence emerged on February 24. My title archivist pulled the physical notary log from the county clerk's office. The notary who supposedly witnessed Arthur's signature in August 2018 was a woman named Elena Rostova. Elena's notary commission had expired on July 30, 2018. She renewed it on September 1, 2018. If the deed was signed on August 14, 2018, Elena would have been operating with an expired seal, rendering the notarization legally void. However, the physical stamp on our document bore her new commission number, which didn't exist in August. The second anomaly was the ink. On March 3, the forensic examiner analyzed the signature page. The printer ink used for the body of the document was a specific HP LaserJet formulation that wasn't released to the consumer market until early 2021. The document was physically created in late 2022. Marcus had printed it, backdated it to 2018, and likely used a compliant notary who was willing to backdate the journal entry, or he simply forged the notary seal himself. At this point, a standard narrative would dictate that I take this evidence to the probate judge, invalidate the deed, and force the commercial building back into the estate. But I didn't file a motion to contest. I let the deed stand. I let Marcus keep the backdated timeline. If you were reviewing this deed, which red flag would you have caught first? Comment 1, the expired notary stamp, 2, the anachronistic printer ink, or 3, the father's medical timeline of incapacity. Let me know below. The reason I didn't contest the deed requires an understanding of municipal tax law, specifically a concept known as in rem jurisdiction and the relation back doctrine. In municipal tax law, certain debts are not just attached to the person, they are attached to the land. More importantly, they are tied to the legal owner of record during the specific fiscal year the assessment was levied. On March 10, my archivist was reviewing the City Council minutes and zoning board filings for the Downtown Arts District. We were looking for standard easements. Instead, we found Municipal Code Section 44B, subsection 9. In October 2018, the City Council passed a massive $1.4 million special assessment for subterranean sewer and stormwater infrastructure upgrades. This assessment was levied exclusively against the commercial properties on Mercer Street. Because of a bureaucratic backlog and subsequent litigation from the Merchants Association, the city never actively collected the assessment. It became a dormant municipal tax lien. It sat in the city's ledger, unrecorded on the standard county title search, waiting for a trigger. The trigger was a change in ownership status tied to the 2018 fiscal year. If Marcus had simply inherited the building through probate in 2023, the lien would have been classified as a general estate debt. The estate's attorneys would have negotiated it down, or the city would have placed a standard payment plan on the property. But Marcus didn't inherit it in 2023. By submitting a quitclaim deed dated August 14, 2018, Marcus legally established himself as the owner of record during the exact month the $1.4 million infrastructure mandate was codified. He had bypassed probate, but in doing so, he had backdated himself directly into the crosshairs of a dormant, non-negotiable municipal liability. He had legally declared, under penalty of perjury, that he was the responsible party in 2018. On April 11, 2023, at 2:15 p.m., a certified letter from the City Department of Revenue arrived at the registered address of Marcus's LLC. It was a notice of immediate lien enforcement and intent to foreclose. Because Marcus claimed ownership in 2018, the city's automated system flagged his LLC as the primary debtor for the 4 years of accrued interest and penalties. The total demanded was $1.82 million, due in 30 days, or the city would seize the property via tax sale. Marcus's cognitive tunneling had been absolute. He was so hyper-focused on the immediate prize, securing the lucrative commercial asset and avoiding probate fees, that he was physically blind to the peripheral threats buried in the municipal archives. When Marcus finally realized what had happened, he tried to retract the deed. He filed an emergency motion in probate court, claiming the 2018 date was a clerical error and that the transfer should legally be recognized as occurring in 2023, after Arthur's death. The judge denied the motion. You cannot use a fraudulent document to secure a benefit, and then ask the court to retroactively correct the fraud when the liability comes due. The court held Marcus to the exact timeline he had fabricated. By May 2023, unable to secure a $1.8 million commercial loan against a property with a clouded, contested title, Marcus defaulted. The city initiated the tax foreclosure. By August, the Mercer Street building was sold at a municipal auction to a commercial developer for pennies on the dollar, just enough to satisfy the city's lien. Marcus walked away with nothing. Meanwhile, the probate process for the rest of the estate concluded quietly in September. Because the commercial building was no longer in the estate, the only remaining asset was the Oak Creek residential home. The house was appraised at $450,000. It had no mortgage. It had no dormant municipal liens. It was entirely uncontested. As the sole remaining heir to the probate estate, the deed was transferred to me, clean and unencumbered. The aftermath of this case study is not just about the redistribution of assets. It is a clinical examination of how greed distorts risk assessment. Marcus possessed the intelligence to orchestrate a complex backdating scheme. He knew how to navigate notary logs, LLC formations, and probate avoidance. But he lacked the discipline to investigate the history of the asset he was stealing. He assumed that because the property was lucrative, it was clean. In family business law, this is a common failure point. Siblings often fight over the crown jewel of an estate, ignoring the structural rot beneath the foundation. They view legal documents as weapons to be wielded against each other, rather than as binding contracts with the state. When I reflect on the timeline, from Arthur's stroke in October to the final foreclosure in August, the most striking element is the silence. Arthur never spoke about the 2018 sewer assessment. Marcus never asked about it. The city never mailed a warning. The entire mechanism of ruin was entirely passive, waiting for someone to sign their name to the wrong year. At the beginning of this case study, I mentioned that the most dangerous document in a probate file isn't the one that's forged, but the one that's entirely authentic. Marcus fabricated the quitclaim deed. That was his deception. But the 2018 City Council minutes were entirely authentic. That was his undoing. He built a legal fiction, but he anchored it to a historical reality he never bothered to read. Trust in a family estate is rarely broken by a single, dramatic confrontation. It is eroded by the quiet, methodical accumulation of hidden ledgers, expired notary stamps, and the silent assumptions we make about the people we share blood with. The weight of a single pen stroke can transfer $1 million asset. But it is the invisible ink of history that ultimately dictates who pays the price.